All right, good afternoon to those of you on the East Coast. For those of you on the West Coast, including myself, good morning. My name is Ari Rothman. I am a partner here at Venable working on all kinds of advertising law issues, representing the California West Coast contingent on this webinar. And I'm joined by my partners, Shahin Rothermel and Claudia Lewis. They are on the East Coast in Washington, D.C., where a lot of these regulations are at least on the federal level, are formed and enforced. And so we've got you covered from coast to coast on this one. And thank you for joining us today about this. Um, we chose these five top advertising issues because it's what we're seeing a lot in our practice. And so these are the five that we're going to cover. Of course, if there's others you want us to cover in a future webinar, just send us an email or drop something in the chat. But here they are. Customer reviews and social media advertising, pricing and free claims, alleged violations of the Food and Drug Administration regulations, which, by the way, those also come into like class actions and false advertising suits and those sorts of things, environmental advertising claims, and something really specific and something that we're seeing a lot of action on relates to PFAS, those so-called forever chemical claims and related issues, expressed and implied. We'll cover that at the end and have a conversation about that because that got sort of hot and out of nowhere. So first up, I'll pass it over to my partner Shahin to address and discuss customer reviews and social media advertising. Shahin, all yours.
Thank you, Ari, and thank you again, everyone, for joining us. All of these types of claims are something that we are seeing challenges from everything, from class action plaintiffs' attorneys in the National Advertising Division, challenges by competitors, the Federal Trade Commission. You have state AGs who are forming task forces that we'll be talking about as well. So all of these types of claims are things that we are seeing challenges across the board. And there are also claims that if you're a company and you're seeing your competitors do these types of things, it might be worth considering whether you want to take some sort of action. And we had a previous webinar that talked about the types of actions you can take against your competitors. With that, the first thing we wanted to talk about are customer reviews and social media advertising. The reason for that is that we are seeing just a huge influx of advertising using customer reviews, highlighting customer reviews. Social media is the way a lot of the younger generations now ingest all media and all advertising. And as a result, the Federal Trade Commission on the federal level has started to really crack down on it and look at it very, very carefully and impose a lot of restrictions. So back in the day, the FTC promulgated guides concerning the use of endorsements and testimonials in advertising. And the general rule of the roads on that were that if you have a connection with your influencer, you paid them, give them something free, that needs to be clearly and conspicuously disclosed as a material connection. And also that an influencer or someone else with a material connection to the company cannot make a claim or say or do something that the company cannot do directly. In other words, companies oftentimes will adopt the statements and the things that are said by their influencers. Now, the FTC has been on a tear recently with its rulemaking, and it has finalized and adopted a formal rule in July of last year that puts more stringent requirements surrounding endorsements and testimonials, and which would also allow for monetary penalties for violations. We're now over $51,000 in terms of what the FTC can get if you violate these trade regulation rules. More recently, in August, the FTC issued a final rule banning fake reviews and testimonials. And that rule really focused on customer reviews and testimonials as opposed to only social media. It looked at things like AI-generated reviews, reviews that misrepresent the reviewer's experience, buying reviews. We've seen that across the board. Companies that want to incentivize reviews, sometimes they'll purchase them or have employees go out and do that. So the new rule has started to address that, and it also goes back to the basic principles of disclosure. The current guidance on consumer reviews are that you cannot solicit reviews that are only positive. You can't say, hey, I'm going to give you a free product if you go out there and give us a positive review. That's what the FTC says. The FTC says you can say, look, we'll incentivize a review if you say whatever you want, positive or negative. You're allowed to do that, but you cannot only ask for good reviews. The new rule also talks about comparison websites and review platforms. We see a lot of companies that have things like top 5 pencils in 2024, and they review various competitors, and those review websites are actually operated by one of the sellers whose products are sold on that website. The FTC has now addressed that and said that you have to be very careful if you're doing some sort of review website when one of the sellers, the sponsoring sellers, has a feature, or excuse me, a product or service that is featured on that website. The NAD has been very active in this area as well. Things like aggregated customer reviews, review websites, #1 most reviewed. Those are all types of claims that the NAD is looking at and that competitors are challenging. So one example of that here was a case of LegalZoom brought against Zen Business. And the claims at issue there were that Zen Business was a #1 rated service. And LegalZoom argued that that was false because it made people believe that it was #1 rated by unbiased reviews, when in reality, according to the challenger, those reviews were controlled by Zen Business and others. In other words, they weren't real reviews, so it wasn't really #1. The other issue was that it wasn't clear, according to the challenger, that the website was actually owned by Zen Business. It looked like it was an independent website that was reviewing the company, when in reality, Zen Business actually owned and operated that website. NAD said that even if you had a disclosure, let me go back to that last one. Even if you had a disclosure that said, this site is owned by Zen Business, Inc., we review our own products and compare them to others in the industry, the NAD said that that disclosure was not enough to cure the quote unquote false misimpression that it was an independent review website. And even though there was branding and other things, the NAD said, we're looking at this page in its entirety, and we think that this is insufficient to show people that this is actually an insider website. Another case involved Bath and Body Works and Goose Creek Candles, where the challenger had an issue with the fact that 4- and 5-star reviews were selectively published and incentivized. And there were also issues about whether or not the advertiser disclosed the material connection. So they would give somebody a free fragrance product in exchange for a review, positive or negative. And then it, as a result, it generated a lot of reviews. We see a lot of companies doing that because they want to get feedback from people, whether it's positive or negative. And the advertiser said, look, we don't ask for positive versus negative. We're just asking for reviews. We're not suppressing negative reviews. The only reviews that we're removing are ones that are clearly irrelevant or not having anything to do with our company. And NAD said, it is okay to do that as long as you are not encouraging only positive reviews. However, no matter what you are, if you are incentivizing them, you need to disclose clearly and conspicuously that there was an incentive that was given there, that free product. And NAD didn't go too far in depth on that idea of suppression. We're taking out some reviews and because they're irrelevant, they don't belong to the company. But NAD said you've got to be careful when you're doing that, because that can be dangerous if you start removing reviews and then distorting what the overall impression of the reviews would be. So how to defend lawsuits challenging customer reviews and related claims. Create policies and procedures that ensure that your reviews are valid and they're from bona fide customers. If you're incentivizing the reviews, make sure you're not only asking for positive reviews. Make sure that you're asking for truthful reviews, positive or negative. Be very upfront. Require those people to clearly and conspicuously disclose their connection with you. Even in those negative reviews, sometimes clients say, well, it's a negative review. Why do I have to say that it's incentivized? The NAD and FTC say, if you've given somebody something for free, it doesn't matter what the content of that review is. You need to disclose the fact that you've given them something in exchange for a review. Document it. You're going to hear us say this. I feel like we're broken records on this, the three of us. Maintain documents demonstrating that these people reflect actual customers. Maintain documentation about your compliance steps taken. If you see something that's gone sideways, if you're seeing like fake reviews and you're taking them down because maybe it's somebody didn't disclose a connection, just making sure that you take steps to document that, because those are the types of things that if we have to defend a challenge that the FTC brings, a state AG, class action plaintiff, or the National Advertising Division, a competitor challenge, those are the types of things that you want to show that to defend yourself in those cases. Now, with that, I'll hand it off to Ari to talk about pricing and free claims. You're on mute, Ari.
Sorry, no, this is another hot area that I mean, we're always, I feel like, dealing with pricing and free claims, but here are the types of challenged pricing that we're seeing right now. One of them is the strike-through pricing and the former price comparison and perpetual sales. So that's when a company basically has a price for a product that it's always advertising as a, and I'm shortcutting it here, but it's always advertising, for instance, as a sale price or something off or something like this. And there's never like a true retail price that the product actually sells at. Or if there is, it's never sold at that price. And so you're leading, the allegation would be that the seller is misleading consumers into believing that they're getting a sale price or a discounted price when in reality they can get that price all the time. And I don't want to, give any specific examples yet. I'll give a couple in a minute, but um, that's a big issue for advertising claims and pricing claims right now. Another big one is junk fees. So these are fees that accompany the purchase of a product or service that are unnecessary or surprising, I guess, because sometimes they come at the end. We'll get to drip pricing in a minute, but they add little to no value. They're just a way to increase the price of a product pretty much unnecessarily. And you'll see class action lawyers and the FTC and some state AGs, they sort of know it when they see it, and they're going to call companies out on it pretty consistently. And then there's drip pricing. That's when you start off advertising the product or service at a certain price. And as you move through the funnel or move through the purchase process, the price increases because you're revealing charges related to that product over time, such that you start with this sort of like entry price when you're starting the buying process, and at the end nothing's changed with respect to the product except the price. It sort of is increased a lot of the time. Sometimes we'll add some junk fees into that, so you might see a hybrid of junk fees and drip pricing. And of course, we've seen instances where we see sales funnels where all of these things are present, and so obviously that's going to increase risk of detection rather than one. So here's one that we see. This is a real life example from a lawsuit filed last year against Michael Stores. Now, for background, back in 2011, um, the New York Attorney General agreed to a $1.8 million settlement over the advertising of 50% off framing coupons as a sale product for at least 104 consecutive weeks. Well, why is that relevant? Because 104 consecutive weeks is 2 years. And so, how is it that the company is selling a product at 50% off? The user might think they're getting a special deal or something like that. Well, not really. The true price is the 50% off, and leading customers into believing that they thought they were getting 50% off was found to be a deceptive trade practice by the New York Attorney General, and so they got hit up with a $1.8 million fee or $1 million settlement, had to settle that for that claim. Fast forward now to the Cara case, which is pending out in California, and that involves California's false advertising law, unfair competition law, and the CLRA, the Consumer Legal Remedies Act, the same three statutes we see in virtually all of these cases. And we we cut and pasted the coupon here, the 20% off coupon, because that is what is triggering these lawsuits, or those triggered this lawsuit. The argument is that everything at Michael's is 20% off because everybody gets this coupon or can take advantage of this, or whatever the situation is. And so even though you're telling the consumer, here's a 20% off coupon, the reality is Michael's behind the scenes is assuming that they're going to sell everything for 20% off whatever the sticker price is inside the store. The advertiser took the position, in this case Michael's, that the advertisements couldn't be misleading because while discounts might have been available, such as this coupon we put up on the screen, not all consumers are aware of them or took advantage of them. And that makes that kind of has some merit to it, I think. The judge, though, said, and I'll give you, literally, I think this comes out of the decision, quote, that may be the case, close quote. But even advertisements, which are technically true, can still be misleading, deceptive, or confusing, and let this case pass a motion to dismiss. I think the whole coupon, the fact that you have to use a coupon or invoke a special is pretty compelling evidence for the defendant. Judge disagrees with me. I don't represent Michaels in this case, obviously. Judge would disagree with my position on it as I'm articulating it here, but this is just an example of what judges are letting through in 2023 and 2024. So if we move on then to a strike-through pricing example, this is from this year, Brooms versus Full Beauty Brands Operations. Here we have the trio again, the California False Advertising Law, the Unfair Competition Law, and the Consumer Legal Remedies Act. And in this case, what the allegation is the plaintiff is alleging that the prices were false, misleading, claiming full beauty inflated the comparison reference prices to deceive consumers into believing the sale prices represented genuine discounts. We'll get into another example of this in a minute involving TJ Maxx. So you have the sort of facts we've laid out here in the bullets where the defendant's in-house branded clothing products on the website were offered at sale prices that were discounted from higher reference prices. But the plaintiff argued that Full Beauty pretty much never sold these items at the inflated prices, and therefore they were fake. This litigation is ongoing, so we'll have to see how something like this plays out. So what are sort of like the practical do's and don'ts that result from this? Well, if there is a true price comparison, and that's the key point, like if there is a true price comparison, disclose that, and obviously any other material terms and offer restrictions. You've heard us talk about those in other webinars. The lowest and highest savings when using a savings claim, save up to 40%. That would be another practical point that we would advise. The number of items available at the highest savings must represent a significant percentage, like typically 10% off all the items offered. That way you're not in a situation. I mean, that's just something that is a statistic that you're going to want to have available if you're attacked in one of these cases. To obviously disclose the offer limitations and like the list prices or original prices. This gets back to my original comment. Make sure those are accurate and real. Like have evidence that you've actually sold those products at those prices. Otherwise, it's fake. I mean, that's what the plaintiffs are going to allege. Do not list comparative prices that exceed the price of identical or substantially similar products for a substantial period. In other words, going back to the list prices, original prices are accurate point, like don't change those. And don't use perpetual sales prices. That's another way of us sort of articulating the point. Don't have a product that's like you always have this list price of $50 and you're always selling it for 40. If you're always selling it for 40, then it's never 50. And so that would be considered a perpetual sales price. And that's something that you're going to get called out for if it happens. Moving on then to state laws that where there's some examples of this. You've got Georgia, Connecticut, and Missouri. And we'll have these slides available for consumption after, but the Missouri one's kind of interesting because in Missouri, there's a presumption, it's rebuttable, that the seller has not complied, and this is a price comparison statute, unless it can show sales of 10% or more of the total sales of the product, not less than 30 days, no more than 12 months. So they've actually given a statistic here in a price comparison statute. That's very specific and an example of the way legislatures are thinking about these. It's also interesting that these are the states that are sort of targeting these specifically, and we're not seeing, you don't see, for instance, in this list yet, Georgia, New York, California, or Illinois, or some of those other big states where you expect to see them from. That said, those states are still going to pursue their own consumer protection statutes and are going to say that these acts that we've been talking about so far would fall under those more general statutes. So just because those states don't have specific things like these three states do doesn't mean that they're not actionable. And we saw that in the prior two slides where the plaintiffs were bringing them in under the false advertising law, the UCL and the CLRA. Then we've got the prevailing market price. This is a little bit different. This is 17,501. This pertains to the original price and the prevailing market price. So this is a statute that basically says if you're going to articulate or advertise the worth of value of anything that is the prevailing market price, it has to be that. And that you can't advertise a price as a formal price if it wasn't that. And so here's a comparative advertising example in TJ Maxx. On the right side, we put compare at $30, then it's $16.99, and then $13. Okay, so here's what we were able to glean from this case. As it turns out, the compare at $30 is not a price, again, from what we can tell, that TJ Maxx ever sold those products at, or that any other retailer sold those products at. Instead, it was some research that TJ Maxx did to conclude that the $30 was about what you would expect to pay if you were to pay at a retail value. That therefore misled, so the argument goes, the consumers into believing that they were saving, in this case, either the difference between $16.99 and $13, or on the one on the right, 18, 12 something, and $10. TJ Maxx ended up selling this case for $8.5 million. I don't know how they arrived at that, but that's a pretty significant settlement for something like this, especially since the consumers got to keep what they bought. So that's a case worth noting. Here's having said all that, it's interesting that we have this sort of like quote that came out of the White House. Not all junk fees that consumers are charged are junk fees. Some are legitimate fees for additional products or services that consumers value. So that's sort of like going to be the test. It's whether or not these additional fees are actually delivering additional value or not. If they're not, they're going to be viewed, at least initially, as a junk fee. If they are, then they're not. Then we have some additional drip pricing, and to give some examples there: hotel resort fees for optional upgrades or add-ons. And then a study found that 14% or more when drip pricing is utilized rather than all-inclusive drip pricing, that consumers are likely to spend more than this. So this is what is driving the increase in drip pricing. At least its prevalence in the market here is, people are buying more when it happens, and that actually makes a whole lot of sense. The FTC rule on unfair deceptive fees. So in 2023, the FTC released its proposed rule targeting these so-called unfair and deceptive fees, and it applies to any business selling in physical locations and online, except for cars, which of course have their own set of rules. The FTC really said it was going to target two things: omitting mandatory charges and fees from advertised prices, and misrepresenting the nature of and purpose of the fees or charges. So that's another way of saying, if you're going to charge consumers for something, especially if it's something in addition to the product or service, the drip pricing example, you have to tell them what it's for and why they're being charged for it. So obviously hidden fees are prohibited. You can't hide fees. That should be pretty self-evident by now, but that's one of the prongs. And then the second prong is misleading fees are prohibited. Again, you can't misrepresent the nature or purpose of the amount of fees or what they're going to be for or how they're connected to the good or service. And they have to be clearly and conspicuously disclosed. We'll give you these slides. I'm sort of shortcutting it for now, but move things along. Disclosing the total price for goods and services. Under this proposed rule, businesses would be required to disclose the total price clearly and conspicuously. The consumer has to know how much they are paying when they click the checkout button. Straight up. That's the simple rule. You can't charge anything more than that at the time of checkout, and you can't charge anything in addition or 2 days later, unless you have certain auto renewal or conversion terms. That's a topic of a separate webinar. Um, it should show up as one charge on their credit card statement too. That would be good evidence if someone ever questions that claim. The total price must be more prominently disclosed than any other pricing information. So like bold, bigger font. And the total price is the maximum total of all the fees and charges that a consumer is paying at that time, except for shipping charges and potentially government charges. Those can be excluded. And so, let's see, it looks like my screen, I'm sorry. So now we're on. Okay, so here's like optional. Here's a distinction between optional and mandatory ancillary goods and services. So if a hotel, these are examples, a hotel offers a consumer the option to purchase or decline trip insurance with a room reservation, or a car rental service offers the option to add baby seats or tipping or gratuity. Um, those are optional. Mandatory services, those are what's listed here. Those would be a processing or service fee that, for instance, if you have to buy a ticket to a concert or something along those lines, and they include that service fee in there, can't buy the ticket without the service fee, telecommunications charges, and those sorts of things. Those are the distinctions. Shahin, could you highlight for us why that matters?
Why the optional versus mandatory?
Yeah, the distinction.
Yeah, I think the idea there is that if something is mandatory that someone's going to have to pay, then that needs to be disclosed. Whereas if somebody has an option, it's incumbent upon me to make a decision, then it's not necessary to disclose it in the same way that something that is unavoidable would need to be disclosed.
That's a good segue, and let's go to slide 27 to move it along. Here are some practical tips to avoid these challenging pricing claims, in addition to all the disclosures that are in the prior slides. Track the prices at which you offer products and services over time, because what that will enable you to do is make those discounted claims later, and you'll have a documented basis for doing that. Track the number of sales at that specific price point over time. So the more sales you have at that larger sale price, the better off you're going to be when defending the discount, even if it's an extended discount. Avoid claims that overstate the discount off the regular prices paid by actual consumers in recent history. That is something that we would recommend that retailers avoid doing, and clearly and conspicuously disclose the full price of the product or service at the outset and at checkout. No surprises. The consumer needs to know what they're paying, how much they're paying, what it's for, and all the services and fees that would be included in that. And retain records of that so that you'll be able to show anybody who questions whether or not that was disclosed to a consumer. You'll be able to point to it as evidence in any kind of challenge. With that, I will turn it over now to Claudia, who is going to move us in a different direction on FDA regulations.
Thank you, Ari. And I would have to say that I'm sure many of you are wondering why FDA is a segment of this seminar, but I have to say that the plaintiffs' bar is an equal opportunity challenger. And they're often and increasingly looking at FDA regulations as a fertile area for deceptive advertising. One thing I would say at the outset to my FDA regulated product people watching this seminar is that Many of the areas that the plaintiffs bar has sort of looked at are very technical violations. They're based on very antiquated, voluminous regulations that the FDA still has on the books, and from time to time does enforce, but it is not something that the FDA is actively enforcing against. But the plaintiffs bar are making some headway with it. So let's look at the areas where we have seen some challenges, and that Ari and Shahin and I are working on currently, even as we speak. We're getting demand letters on these types of things. So your calorie declarations, your sugar content, your carb claims, all of those are fertile ground for the plaintiffs bar these days. And we have seen a little bit of an uptick in competitor challenges on these types of declarations on labels. So in instances where companies are understating the number of calories or suggesting that the product is free of sugar or that there's no sugar added, that you're focusing on carb claims and you haven't done the proper calculations, the plaintiff bar is looking at technically with the FDA regulations and seeing if you comply, and then making a demand letter about it. And so many of these claims have lots of rules and regulations. So calorie content, there are certain ingredients that are excluded and included. Your zero sugar claims, all of those rules are outlined and very technical. So under the zero sugar, you can't have over a certain amount of sugar to using that claim. A lot of times people overlook the fact that not only can there be no ingredient that is sugar, there can't be ingredients that consumers understand to be as sugar to use that type of claim. And it must be a low calorie food, or if it's not a low calorie food, you have to state that it's not a low calorie food. That disclaimer and some of those sort of disjointed way that FDA regulations are written is where the plaintiffs are coming in, and it's a sort of a gotcha moment, and we're writing checks for that, unfortunately. The next area that's been a huge uptick is protein content claims. We're all looking, as I get older, I'm looking to have more intake and easier intake of protein. People are looking at alternative sources of protein. There's a lot of consumer interest in vegan and vegetarian sources of protein. And so I think all of us know that not all protein is equal, and the FDA regulations sort of reflect that. And so there have been challenges where the protein content claims are deemed misleading because sometimes a manufacturer might assume that the protein content is going to be X based on the addition of milk or another ingredient that might be protein rich. Sometimes the products are made with low quality proteins, so the human body doesn't absorb them the same, or it can't utilize them the same. There's also the PDCAS is something very popular right now. Depending on what type of protein you're using, you have different calculations the FDA is looking. Whey protein is sort of the standard that the FDA is looked at, and if you have whey protein, then you can use sort of the standard calculation. But if you have maybe soy or peas or other types of vegetable sources of protein, those may have to have a different protein calculation so that the actual protein content on the label is accurate. And often when you get these cases, you're like, how do you even know whether this is accurate or not accurate? And that's one of the reasons why the FDA is not actively looking at it, because it's very expensive to test and sort of look at these types of technical declarations very closely. But the plaintiffs bar, believe it or not, testing products to see what's happening. And so they're sending along with the demand letter test results, and Ari and I are sort of scratching our heads, and Shahin, like, what are we going to do with this? If these are accurate and this is our product, where we go from here. The other area, and the reason why it's not bolded like the other two, is that clean and simple claims, so many also consumer driven, just like the vegetarian and vegan source of protein, clean and simple claims are on all of our food products. It's being attached to ingredients, it's being attached to plaintiff's bar as sort of bleeding it over into our packaging. And so these three categories are where the plaintiff's bar is spending a lot of its time, despite the fact that there's not a lot of FDA action on these particular claims. Next slide, please. And I wanted to give an example of the sugar and carbs claim because we talked about it in the context of FDA and what having very technical regulations. And I'm happy to go through those after this. I didn't want to bore, pricing and social media webinar with all the FDA technicalities, but I think it's worth highlighting that not only is the plaintiff bar looking at these types of things, but your competitors are also looking at your labels, scrutinizing them, and sometimes challenging before the NAD. In my view, I feel like these types of, whether your sugar and carb claims or declarations are accurate, really is within the purview of FDA's jurisdiction. And I feel like there's a statute in place and an enforcer in place, but where NAD is really stepping into a place where they feel like these can be deceptive advertising claims. So even though there's some room to argue that this should be something that the FDA should be handling, the NAD is increasingly taking FDA regulated issues and opining on them. In this particular case, we have Ole Mexican Foods. They have tortilla chips. I don't know whether they're delicious, but I like tortilla chips in general. They made a bunch of claims about the total fat servings. They made a claim about zero net carbs. They talked about 0 gram sugars and zero sugars, and absolutely zero net carbs. Believe it or not, each of those bulleted points is something that's regulated by FDA. There's very technical regulations. Sometimes they're contradictory and not easy to follow. But here, the competitors are saying, regardless of how technical and complicated they are, there's something on its face that's deceptive in this instance. And unfortunately, this particular company used a very small serving size. And so probably less than 10 years ago, FDA updated its serving size on the nutrition facts panel to sort of reflect our eating habits. A lot of it looks like it was directed at me. I was like, oh, someone's noticing that I'm not eating just 3 teaspoons of ice cream, but the whole canister. So that's where that generated from. So that people could sort of associate their eating habits with what they were reflecting on a label and not having to do so much math. And so the advertising took the position that the small serving size, which was, I think, 1 tortilla or 2 tortillas, made all the other claims about the sugar and the carb content deceptive. The NAD agreed. If we can go to the next slide. So the NAD found the claims misleading based on 1 tortilla serving size, and based on the regulations specifying what a per serving actually should look like. And as a result, most of the claims, sort of looking at FDA regulations, the NAD determined that they had to discontinue the 1.5 grams total fat per serving for this particular product. And they suggested that the advertiser modify all of the other claims based on doing the appropriate calculations based on the appropriate serving size. And you heard, so now let's move over to the clean and simple claims. For those of you who work with me know that the FDA is actively looking at ingredients and looking at the safety of ingredients. They're also looking at what clean and simple claims mean. Can we go back one? Yes, thank you. And so we have, so NAD, so Shahin talked about one aspect of it, but here's where the FDA portion is it, the NAD requests information about express and implied claims about avoid harmful chemicals found in their body care products or found in other body care products. Many of today's popular candle brands make products with inferior and potentially unsafe ingredients. The candles of Bath and Body Works and other Goose competitors are made with harmful chemicals. So just a very concentrated and focused on the ingredients in a candle product, which also can be a cosmetic product depending on the types of claims here. And NAD indicated that so that I'm sorry, that the advertiser, I apologize, I've lost my train of thought. It looked like some of the ingredients in the candles were banned ingredients in certain states, and that they were not safe. And NAD found that the statements reasonably conveyed that these products were harmful, and that consumers would take the message that these types of ingredients weren't safe for use. And so NAD recommending that Goose Creek Bath and Body Works in this instance, discontinue all claims suggesting that the competitor products contain harmful or unsafe ingredients, and they agreed to permanently continue the use of those ingredients. And I think one of the things I want to talk about is that, so there's a technical aspect of the FDA regulations that competitors are seizing on, but there's also an ingredient piece. And the FDA is very focused on the ingredient piece. And in the context that we're going to talk about later on PFAS and other things, that's where there's a connection here where FDA has a new edict and a priority that they're going to be reevaluating how it looks at the safety of ingredients, not just in the food space, but in any product regulated by the FDA. So here are some ways to defend lawsuits challenging FDA regulated claims so that we can get ahead of the curve a little bit. I just encourage you, review your label carefully and confirm that testing validates the label claims. That is structure function claims, that's your nutrition facts panel. It's all the things that consumers are going to read to determine whether they're going to purchase your product or not. I also suggest that you review the ingredients in products to ensure that they meet the relevant standards, including those for protein claims. Hot protein is very, very hot. That PDCAS is a very hot topic right now. And Shahin and Ari put out a really good advertising log, client alert, and blog, and I often include hot ingredients that have been determined that are not necessarily been determined, but there's a question about whether they're safe or not. And I would also implore everyone to analyze any clean or simple claims that you use to make sure that they are in keeping with the message that you intend. Sometimes these clean and simple claims can morph into natural claims. They also can morph into not just the product itself, but the packaging. So there's a lot of things that this clean and simple can be expressed and implied that we want to be mindful of. And with that, I think I'm going to turn it over to Shahin.
Yes, and this is something that we would be completely remiss if we didn't talk about in this webinar. It's environmental advertising claims. And this is something that really dovetails well with what Claudia just said about being careful about what the express and implied claims are that you're making. Before I continue, I will give everybody the CLE code. It is challenged 2024. Challenged 2024. Now, environmental advertising claims, I think, 10 years ago, we would have seen this really specific to certain types of products and certain types of verticals. We are more and more seeing environmental advertising challenges to all types of products because companies are talking about not only what's the environmental attribute with respect to this, plastic product that I sell, but also what's the carbon footprint of it? How was it made? What was the environmental impact? What's its end of life experience? Do I recycle it? Can people reuse it? And as a result of that, I think that we're starting to see a lot more challenges on those issues. And we talk a lot about the word greenwashing. And Claudia and I had a podcast on this, if you listen to our podcast, about the so-called greenwashing. But the problem has become that these lawsuits are so prevalent that we're starting to see the pendulum swing over to green hushing. Companies are now afraid to talk about the benefits that they have in their product and the life cycle of their products, even though they spend money and resources to try to minimize their environmental harm and impact. The trending litigation that we're seeing, I'll start by saying the FTC has still not updated the green guides. We're still waiting for the most recent green guides to come out. The last ones were updated in 2012, so you can imagine they're quite out of date with the science and just where we are as a society. we're continuing to see general challenges on eco-friendly claims, environmentally friendly claims. But we're also starting to see challenges involving aspirational claims. Hey, this is what we are doing as a company to try to help in the future. And we're talking about our goals. We're not saying we're doing this right now, but we have these goals, we're working towards them, we're trying to reduce our impact over, over the course of the next 10 years, 20 years, 25 years. And we're starting to see a lot of lawsuits challenging those. We'll talk about those. The other that we're starting to see are the technical claims, biodegradable, compostable, recyclable. There's some very technical laws that are coming out or that have been on the book that are starting to be challenged and litigated in states like California. You've got Washington, you have New York. So just being mindful that it's not just the FTC green guides from 2012 that are going to be controlling or that you should be looking at. In California and Washington, for example, if you're making certain types of claims, they have to be supported by certain types of ASTM tests. So you've got the California Greenwashing Task Force. You have Washington State that's begun sending educational letters. And we're starting to see lawsuits by states like New York and California against very large companies. Talking about aspirational and sustainable claims, there was a lawsuit that was brought against Coca-Cola. It was talking about its aspirations to be a sustainable company, to commit to reducing plastic pollution, and basically having an environmentally friendly image. And the plaintiffs allege that this is, you're a company that sells a plastic product. You can't portray yourself as, consumer or environmentally friendly. And Coca-Cola said, no, look, these are aspirational. It's not really something that you can prove true or prove false right now and today. And the lower court said, they agreed with Coca-Cola. They said, okay, yeah, we agree that these are just general aspirational claims. Coca-Cola doesn't have to have very specific evidence demonstrating that 10 years from now, it's going to actually meet that requirement. The appellate court disagreed. It overruled the lower court. So even though Coca-Cola was successful in the motion to dismiss at the trial court level, appellate court disagreed. Another case that came out, I think, a little bit earlier this summer was against Lululemon. And the allegations there were that back in 2020, so 4 years ago, Lululemon had this campaign called Be Planet, and it talked a lot about the types of things that Lululemon was doing, that it had a commitment to the planet, that it wanted to avoid environmental harm. It had some really general statements, like Claudia was talking about, sort of those general statements, but then it also had some very specific statements that you can see here on the slide. Things like having an end-of-use solution for 100% of our products by 2030, reducing greenhouse gas emissions with the supply chain. Here's the problem. Now, this was back in 2020, so that was 4 years ago. 4 years later, so somebody was watching them. 4 years later, the plaintiffs file a lawsuit and say, you haven't done any of this. And to the extent that you have made some inroads, they're very small inroads. So for example, maybe there were phase 1 reductions, but not phase 2 reductions. Maybe there were reductions in the Lululemon owned plants here in the United States, but the 99% of Lululemon's clothing were produced in other countries that had a much higher and larger environmental impact, water use, carbon emissions, and that type of thing. So, in that case there, then the plaintiffs looked at the FTC's green guides, and we see this a lot. The plaintiffs will go after whatever they can. They'll go after the green guides. They'll go after the FTC regulations. They'll go after the specific California statute requiring an ASTM test. They'll go after what does FDA say? What does FTC say? And they'll really just find whatever they can to support it, because if there's somebody that says it, then the plaintiffs can say that that's one reasonable interpretation, and then that's one of the reasons and ways that you have to substantiate it. So this case is ongoing. We're keeping a close eye on that one. I'm going to move forward a little bit because I know we're a little short on time. And I want to talk about ways generally to defend lawsuits challenging environmental claims. Review your advertisements in their entirety and consider the potential implied claims. We've seen cases where you've got colors. They're saying, the plaintiffs say, you've got a lot of green and blue, so it looks like the earth, and therefore it means it's environmental friendly. I think that's a stretch. But the problem is that once you start compiling multiple claims, it's cumulative. And sometimes the sum is greater, the overall is greater than the sum of the parts. You're beating a drum. And so looking at your advertising in its entirety, if you have some sort of campaign that you're talking about your environmental goals towards environmental friendliness, just be mindful of that. Consider the language that you're using to promote your social benefits and efforts, because plaintiffs are now talking about, okay, there's something that says we're doing this to avoid harming the environment versus we're doing this to help the environment. So they're starting to distinguish on that basis too. And if you're making aspirational claims, making sure that you have documentation demonstrating that you are going to reach that goal, or at least you have a reasonable basis to reach that goal. I always make this this analogy. It's January 1st and I want to lose 30 pounds, right? And now it's, let's say, I've got 1 year to lose 30 pounds. And then by mid-year, I've gained 30 pounds. So now I'm 60 pounds down. Now, like that's not going to work out. That math is going to be basically impossible. And so that's what we're seeing with a lot of these companies, right? Is that they're making these goals or making these statements, and rather than moving towards it, in other ways, they're moving, in the opposite direction for various reasons, including efficiencies. But just being mindful, if you're going to make a statement that's aspirational, you will be held your feet will be held to the fire. Not so much like, my New Year's resolutions, which are not losing weight, but, same thing. And stay current on the developments, because there are a lot of foot faults in this area. As I talked about the ASTM test, there's, the resident ID numbers on the recyclable claims, making sure that you have a certain percentage of people who can actually recycle a product if you're claiming that it's recyclable. So really keeping an eye on those if you want to make any type of environmental benefits claim. The last area that we'd like to talk about, and I'm opening this one up to Claudia and Ari, because this is just a really big one, are PFAS-related claims, both express and implied. Claudia, do you want to start a little bit about, I know we don't have a ton of time, but just give a really quick background on this.
Yes, and so I think that one of the questions, and I think that Shahin and Ari, we talked about this as we've been trying to war room how we're going to address this, is that there's so many PFAS out there, and it's something that the FDA has on its agenda to look at more closely, to have, help sort of corral some of this. But they're really like 4 to 6 PFAS, or ones that we agree are PFAS, that have really been studied, and that there's some evidence that there's some adverse effects in connection with them. Now, whether that's like an express adverse effects or you have to be exposed to it for 10 years, I don't know the details on that, but I do know that in terms of if you're connecting the unsafety with some kind of data, that world is a little bit small. And I think that part of what the FDA has said they're going to do is look at the 4 to 6 that have been evaluated, and then they're going to start expanding their list and provide some feedback on that. So I think that not all PFAS are created equal in that regard. And I think that one of the things that forever chemicals, I'm also sort of like, well, if we agree that they're forever, how do we, make them safe, or what do we do about that?
And this is something we're starting to see a lot of, is if a company is making any type of claim about environmental benefits, eco-friendly, or any type of safety claims, what plaintiffs are more and more likely to do is say, well, okay, well, if you're making a safety claim or you're making something about a claim about the environment, then that's an implied PFAS-free claim. And if you have any amount of organic fluorine in your product, that is inherently false. And I think that this is a struggle for me. When these cases started coming out, I felt like this was a very difficult case for plaintiffs to bring, and we've started to see that many of them do have legs. One of the theories that we're seeing more and more of as well is that if you're making a free of claim, plaintiffs and regulators are saying that's a PFAS free claim. You got any level of organic fluorine in there, you're making a free, let's say free of harmful chemicals, for example. That's a very broad statement. But free of, just free of bad chemicals, things like that, that's going to be a PFAS free claim according to these plaintiffs and the regulators. So just being mindful that when we're talking about environmentally friendly claims, safety claims, any type of ESG claim almost, those are being interpreted to mean you're free of PFAS. And today I think PFAS are the hot thing for various reasons. I think one of them being what Claudia was saying about the study and the science, but I would not be surprised if we have a new PFAS like type of category of chemicals coming down the pike, over the next few years. So just again, being mindful if you're making these types of claims that they'll be read into very, very closely by these plaintiffs' attorneys.
They're everywhere. Like, yeah, that's exactly the slide I was asking to show the group. Like, why did we choose this as one of the 5 topics? It's this slide. Like, the plaintiffs are claiming that you can find PFAS everywhere. It's hard to figure out what is not included based on this list, which kind of says it all. We can give you some more specific examples if we go to slide 48. Juices. Well, the uptick's also interesting. I guess we could do that quickly to just show the why we chose this, because it's going to go up, and my guess is it goes up in 2024 because judges are starting to allow these plaintiffs to get past the motion to dismiss stage. And so we haven't seen, I don't know that I've seen anything on summary judgment, certainly not at trial on either recent cases, but we'll be looking out for that in 2025. But the advertising targeted juices, this gets to Shahin's example, all natural, simple ingredients, not if there's PFAS in it. Obviously, the diapers on PFAS free. I mean, if you've got PFAS, that's like a really extreme example, but free from harmful chemicals. These plaintiffs are alleging, some plaintiffs, lawyers that we've seen allege that any PFAS is harmful. And so if it's in the product, whether it's intentionally added or not, it can be a harmful chemical. The mattresses, the chemical free and the eco-friendly, doesn't even have to be mattresses. You put an eco-friendly claim on any of the things related to slide 46 that have PFAS in them, the plaintiff's bar might very well say that claim can't be in there. I'm getting a reminder just to say the code again. It's challenged 2024. The CLE code is challenged 2024. So here's an example of why this is such a hot topic right now. Sheen, do you want to wrap it up for us?
Sure. Yeah. So we've got some more examples of the types of class actions that you can see here, but these are really the ways to defend lawsuits or reduce the risk of these types of lawsuits, is being careful about the general environmental friendly claims, the ESG claims. If you're importing a product that contains PFAS, determine whether or not reporting requirements are applicable to them. Here at Venable, we actually have a whole PFAS working group of folks who live and breathe these things. So, if that's something that you're interested in learning more about, we have a group very much on top of those as well. So, just being mindful that this is the next big thing, and to the extent that they may or may not be unavoidable, considering what you can do, whether there are disclosures to be made, whether you've got to be more mindful with your advertising. The final note that I'd like to talk about are additional things that we did not talk about today. The reason for that being that we didn't consider them claims as much as marketing type things. And so automatic renewal programs, Venable's auto renewal solutions team, VAST, we're on top of that. The FTC just issued its click to cancel rule. We're going to be doing a webinar on that here coming up pretty soon. Alleged violations of wiretapping laws. SEPA, California, they're challenging chatbots, cookie, any type of website scraping. Email marketing lawsuits are becoming more and more prevalent, where even like the subject line of an email is being challenged under hyper-technical email laws that provide for $1,000 or more in statutory damages. So if any of these are areas of interest to you, please feel free to reach out to any of us and say, hey, want to learn more about this, do a webinar on this, and we are happy to do that. So with that, I know we're at the top of the hour. We've gone over. If you have any questions, please feel free to reach out to us. And thank you so much for joining us today.
Thank you.